what comes along with this as well is that you're responsible for taking care of this body, and if the body becomes sick, or if there's a threat to the health of the body, you have to seek treatment. And sometimes that treatment has to be aborting a fetus in order to save the life of the mother. So then it becomes obligation. And again, under that heading of pikuach nefesh.
Great, thank you. That was 10 seconds. So Oren and Emily, you are our legal experts. And Emily, you are even more the legal expert. I was wondering if you could tell us maybe a little bit about the history of Roe v. Wade and even just how it got started. What happened in 1973 that brought us to this discussion?
Sure. Can you hear me? Yeah, great. So Roe versus Wade was a case decided by the U.S. Supreme Court in 1973, as you noted. It originated out of Texas. The state of Texas had a law prohibiting abortions in most circumstances, and a woman who was seeking an abortion, who was going by the pseudonym Roe was not her real name, filed a lawsuit challenging the constitutionality of the state law prohibiting abortions. And the case eventually made its way to the United States Supreme Court and was decided in 1973 that there is a right under the United States federal Constitution for a pregnant person and their doctor to make decisions about abortion without state interference. And the Supreme Court in the Roe decision set up what is called sort of a trimester framework for assessing that balance between the decisional freedom of the pregnant person and their doctor and the state's interest in regulating abortion care. So in the first trimester, the decisional freedom sort of completely trumps, and according to the Supreme Court, the state doesn't really have any interest in regulating access to abortion care. In the second trimester, the state can regulate for purposes of the patient's health, but they cannot prohibit abortion entirely in the second trimester. In the third trimester, the Supreme Court said that countervailing interest in the potential life of the fetus gets to the point, when around the time that the fetus becomes viable, that state's interest in protecting the potentiality of that life can be sufficient to override that decisional freedom entirely, and a state can completely ban abortion at that point. So that was the framework set out in the Roe v. Wade decision for assessing when and how states could regulate access to abortion.
And my understanding is that they used the 14th Amendment to create this decision. What else does the 14th Amendment guarantee?
So the 14th Amendment, which was added to the Constitution after the Civil War, applies the first 10 amendments to the states for the first time. So prior to the 14th Amendment, the federal government was restrained by the Bill of Rights, but state governments were not actually. So the 14th Amendment says state governments are also constrained by these same things. For the freedom of religion, free speech, freedom from unreasonable search and seizure, those things also apply to state governments. And it also said that states have to treat people equally. So it has sort of an equality component and then a liberty component where it says the states can't deprive people of these rights without due process. The basis for the Roe decision was the idea that within that zone of liberty interests that are protected by the 14th Amendment is things that relate to our private sexual and reproductive and family relations. So even before Roe v. Wade, there was decisions that said, for example, the decision of married couples to use contraception is one of these private decisions that the state cannot interfere with. And so Roe was building off of those decisions around that realm of privacy and really like intimate things around reproduction sexual relations, family matters, and applying that to abortion as well.
Thank you. And I think for all three of you, how have you seen that decision start playing out in the world? How have people reacted to it? How have people supported it or not supported it? And what has been the legal repercussions around the Roe decision?
I'll start with the legal. So most immediately after Roe was decided, folks who opposed the right to abortion started developing a legal strategy to try to cut it back, basically. And so there was all sorts of laws passed in states. Illinois was actually one of the vanguards in passing laws that tried to restrict and regulate who could have an abortion and when, and requiring spousal consent and requiring parental consent and those kinds of things. And there was lots and lots of litigation in the federal courts about what types of regulations of abortion were permissible. That led to the decision in '92, the Planned Parenthood v. Casey decision, which came out of Pennsylvania, in which it was a moment in which there was a possibility that the Supreme Court would just completely overrule Roe versus Wade, we're in another such moment now, which I think we'll get to, but that was also a very distinct possibility in 1992. But what happened is that instead of overruling Roe and saying there is no right to abortion in the Constitution, the Supreme Court in '92 said this right does in fact exist. We are affirming that this right exists. We are changing somewhat the legal analysis. So instead of this trimester framework, which I had previously described, they went to something that they call the undue burden standard. So after fetal viability, states can prohibit abortion. Prior to fetal viability, they can't prohibit abortion, but they can regulate it in various ways if it doesn't impose an undue burden on people's ability to access that care. And then, so what we've seen since 1992 is lots of legal battles about what kind of regulations create an undue burden. So we had the whole women's health case out of Texas 5 or 6 years ago now, where the state of Texas passed what we call TRAP laws, targeted regulation of abortion providers, and they said basically, even though abortion is a very simple in-clinic procedure, that you couldn't provide it in an outpatient setting, a traditional outpatient setting, abortion providers had to have doors that were a certain width and hallways that were a certain width and all these other things that were not medically necessary. And it forced a lot of providers to close because these were extremely expensive upgrades that weren't justified by what it actually took to provide abortion care. So those were challenged as an undue burden.
Let's add one thing to this, which is that was the intent of the law.
Yes.
The intent was actually shut down the facilities in these states that could perform an abortion.
Right. So that case did make it to the Supreme Court. Fortunately, at that time, in that case, the Supreme Court said those could potentially be an undue burden. And that particular law in the state of Texas was rolled back. But on the ground, what we've seen around the country is states that are hostile to abortion find whatever mechanism they can to try to make it harder for people to access abortion care, harder for providers to provide it, harder for people to access it, and they throw whatever they can at the wall, and they see what will stick under the undue burden standard, and in some places a lot has stuck. So there are parts of this country like Missouri and Kentucky that currently only have one abortion clinic for the entire state because of how many regulations and how difficult it's been made. So even though in those states technically you still have a legal right to abortion, because there have been so many regulations of it, it's not actually accessible for a lot of people, and particularly people with low incomes, people in more rural areas, young people, communities of color, all the people you would imagine would be the most disenfranchised. So that's sort of been the legal back and forth to get us to where we are today. Obviously, that legal strategy was compelled by a public reaction, which if Oren might be able to speak to a little bit better than me.
Sure, so one of the interesting things, if you look at the long-run public opinion polling on abortion rights since Roe v. Wade, is that it's virtually unchanged, meaning that the American public overwhelmingly supports the principles laid out in the decision of Roe v. Wade and overwhelmingly opposes the idea that abortion should be banned and criminalized in America. And I'm using those words intentionally because where we're on the cusp of is the banning and criminalization of abortion literally in at least a dozen states the moment Roe v. Wade is overturned, and likely in another 12 or 13 states shortly thereafter. That said, depending on how you answer the question or ask the question in the public opinion polling, somewhere around 60 to 70% of the American public thinks that abortion should be legal in most or all cases. If you ask it in the reverse, meaning should abortion be banned in most or all cases, it's about 20 to 25% of the American public supports that. So the deeply ironic thing here is that the public debate about abortion rights in America is settled and has been settled for a very long time. America is an overwhelmingly, unquestionably pro-choice country. But since 1973, there has been an aggressive and concerted effort on the political side and on the legal side of this fight. Emily talked at great length about the legal apparatus. I want to be very careful and respect the nonpartisan nature of this dialogue. That being said, central to part of what's happening in our national politics, with an emphasis on running for office, is there are organizations in this country who basically say if you want to be nominated to an office, you have to be 100% unconditionally opposed to abortion. A decade or two ago, there was space in that debate, probably intentionally, for some exceptions: rape, incest, and the health of the mother. Today, if you turn on a Sunday morning talk show, Meet the Press or Face the Nation or one of the others, you will hear governors of the United States openly stating that they do not believe there should be any exception whatsoever, and that if a bill is put on their desk to completely ban and criminalize abortion in the state, even if somebody is raped, they were going to prioritize the fetus over the victim of rape. And so, unfortunately, when the final decision to overturn Roe falls, which we were talking about this beforehand, could be today, or could be tomorrow, could be...
Won't be today.
Won't be today.
Could be tomorrow.
Could be tomorrow. Could anytime in the next 2 weeks. We're going to know by the end of this month. There are states in this country that have something called a trigger law already on the books, and it's pretty straightforward. Abortion is banned in the state the moment Roe v. Wade is overturned, and according to the analysis that organizations like the ACLU does and others, we think 25 or 26 states, which by the way represent something like 60% of the American population, will ban and criminalize abortion fully in the near term. So that's the reality of both the legal and the political moment, even though the people who are advocating for the issue have lost the public battle, they are winning the legal and political fight.
And do you find that in the most part that people are arguing from what they consider to be a religious perspective? That when, that aside from the getting into the courts, people who are advocating and really pushing and pushing their political leaders to do this are coming from what they would consider themselves as a religious perspective?
Certainly there are a lot of people in the anti-choice movement that are motivated by a religious perspective, and a particular religious perspective that they have been taught by their denomination. I do think we should not paint paint with a broad brush everyone who opposes abortion. There are a lot of people for whom for them it is moral or ethical, or they believe from a moral or ethical standpoint that abortion should be limited, and it doesn't necessarily come from a particular denomination. There are also some groups that are like, they call themselves like the progressive anti-choice people, or they call themselves the progressive pro-life people, but like they believe they're vegetarians, and they try to frame it as we have respect for life in all its forms, and a consistent position in respecting life in all its forms would be to prohibit abortion. So that is a smaller subset of the movement to criminalize abortion, but obviously a big motivator for a lot of people is their moral and ethical beliefs, and not just that, but what they are told by their church or congregation is the appropriate moral or ethical belief.
Yeah, I found it fascinating that in the state of California, most recently, one of the, I believe it was the Archbishop in San Francisco, was going to deny communion to Nancy Pelosi because of her pro-choice stance. And there was an interview that I heard of another Catholic bishop in California who was being interviewed by a reporter who was really trying to get that gotcha moment from the Archbishop. And to his credit, he wasn't going to take it. And what he presented was, yes, we, as a Catholic Church, we believe that life, full life, begins at conception. And so for us, the consistent approach to that is that, yes, at any point along the line, if you destroy that life, you are destroying a life. And it would be as whether it's a person walking down the street or the unborn child. And at the same time, he was completely against criminalizing abortion. That, we have to, he used the word compassion, and that's what we teach compassion, and she kept, this particular reporter kept pushing, well, what, are you going to help the parents? And yes, we have very, very generous, benevolent people in our community, and that's the approach that we should be taking, rather than pushing for criminalizing and imposing what we believe to be true upon others. And I thought that was a very powerful and important voice, and one that isn't heard often enough, in that, we have freedom of religion in this country and freedom from religion in this country. And people don't get that. And don't get that. For the most part, people are arguing, and you qualifying and saying moral and ethical, and I would still say that's coming from a religious perspective, and saying that this is how it should be, not just for me and my community, but for everyone, and imposing that on everyone, which is, again, not the compassionate approach, not the just approach, and not treating people with dignity as free moral agents.
So and I think what both of you are saying is really important, which is to say that like the average person in this country doesn't have sort of an absolute posture on this issue, right? Like we've had Emily and I have worked together for a long time on a lot of legislation in Illinois, which we can talk about, and some of that legislation has been easier to pass, some of it's been a little bit more complicated, and sometimes we have to look at each other and say, the pro-choice voters in this state aren't where we are. And figure out how do you still organize and pass a law, that one's a particularly difficult one. I think there's two things that I want to just touch on. One is that there's the activist base and what they're trying to accomplish on the issue is different, I think, than the position and posture of the average voter. Some of whom may end up voting for one party or another based on a long list of other factors. That said, I do think it's really important to acknowledge something here, which is we are socialized into a society that tolerates the idea that men, and I'm saying men here specifically, because most of the people making laws in this country are men. Most of the judges on the Supreme Court are men. We have been socialized into a country in which we think it is just, moral, ethical, or a legitimate use of power for men to make decisions about what other people are doing with their bodies and, by the way, with their families. Most of the time impacting women, but also impacting trans people, non-binary people as well. The only way you get into a place culturally where we treat that as legitimate is if the underlying fabric that we've been socialized has inserted this idea, and this idea is around the notion of being pro-life. And that notion in particular comes out of religion. Whether we want to acknowledge it or not, the reality is that religion is central to American culture, although not all of us are terribly religious. I wear a kippah in public. It's not for religious reasons. I'm not going to distract us with that. But the point being that the American culture has been heavily informed and influenced by religion for the last 300-400 years that we've been, evolving what we are. The role of the church or churches and synagogues in establishing that culture is so dominant that from my perspective, when we ask the question of whether or not it's religious motivation or not, I actually think it's starting in slightly the wrong place, because I don't think that we would arrive at the conclusion that I have the right to tell you, Emily, what to do without the underlying air that we breathe socially and culturally on this question, and this question derives, in my opinion, out of religion. And so I think the answer is yes, although I don't think every individual who arrives at their position on this issue is thinking quite as deeply as I just communicated. But I think it's important to state that.
And so you mentioned that Oren, you and Emily, your work focuses mostly on the Illinois component of how Roe v. Wade shows up. What does your organizing work look like? What does your legal work look like? And how are you getting to those pro-choice or anti-choice people in order to do that work?
So for a long time in Illinois, the work was very defensive. And as I said, immediately after Roe came down, states were passing all sorts of regulations and restrictions and really testing the boundaries of how they could limit abortion access, and Illinois was really in the vanguard of that. And so things like these trap laws that make it really hard to operate an abortion clinic that really became more widely known publicly only in the last decade or so, Illinois passed that in the 1970s. And then the ACLU of Illinois had to go to court and had to file lawsuits to argue that this was interfering with people's rights under Roe v. Wade. And fortunately, for many years, especially between the Roe and the Casey decisions, where we had this very clear trimester framework on what states could and could not do, we were able to get a lot of stuff enjoined. And so we had a lot of terrible, terrible law on the books in Illinois, but in practice, because of different court injunctions and consent decrees that the state had agreed to, we had a somewhat favorable environment for abortion provision. And that was the case for decades until the last 10 to 20 years, where because of the work of organizations like the ones that Oren participates in, like Personal PAC, we really have, there has been a concerted effort to elect people to statewide office who are supportive of reproductive rights. And that gave us the opportunity to switch from this defensive mode into a more affirmative, proactive mode. So we took the steps to get all of these bad things that were on the books off the books, because we knew that Roe was at risk, and the reason that we weren't enforcing all these bad laws in Illinois was because they were unconstitutional under Roe. So if Roe went away, we might suddenly be subject to all these bad laws. So Oren mentioned a trigger law, which basically is a law that says if the Supreme Court ever overturns Roe, our state bans abortion. We had one of those on the books in Illinois until 2016, 2017, I don't remember what year HB 40 was, but 2017. We had all of these trap laws and other really bad laws on the books that we had to get rid of. And then we said, okay, not only do we need to get rid of all these bad things, we also want to put some affirmative things into our law that make it very clear that under Illinois law, you have the right to make your own decisions about childbearing, whether or not to have an abortion, whether or not to use contraception, decisions around when and how you give birth, IVF, exactly. So we passed the Reproductive Health Act in 2019, which creates a right in Illinois for all people to make those decisions without unnecessary governmental interference. And so we moved out of the defensive mode and out of getting rid of the bad stuff into affirmatively protecting things. And then just this past year, there was one remaining abortion restriction on the books here in Illinois, which was mandatory parental notification for abortion. And we were able to get that repealed as well. We know that the majority of young people voluntarily talk to their family before they have an abortion. Those who were being harmed by this law were those who were not coming from supportive households, who were at risk of abuse or being kicked out of the house. So that law has now been repealed. So we now have a situation in Illinois, finally, where we have good laws on the books. We have a conducive environment for abortion access, fortunately just in time to probably become one of the only states in the entire Midwest where abortion is available.
Yeah, and one of the ironic things is people like Emily and myself would be out, in 2017, in 2018, in 2019, talking about not if, we were talking about when Roe would go. And people would look at you like you were crazy. That could never happen. And I understand, right? Like, it's hard to imagine a situation in which the Supreme Court of the United States rolls back a constitutional right. That's not been our experience. But when we started down the path of HB 40 in 2017, talking about this trigger law, right? Donald Trump had just been elected, and when you talked about a trigger law to people, they would look at you and be like, no way is Roe v. Wade going to be overturned. But we took politicians like him, forgetting party for a second, politicians like him at their word when they said their goal was to overturn Roe, and we watched what was happening across the country, especially since 2010. There were more, starting in 2010, there were more abortion restrictions passed in the states across the country than had been done in the previous 15 years over a 5-year period. From 2010 to 2015, there was more in those 5 years than in the previous 15 years, and the only reason they were doing it, and they were open about this, was they wanted to bring case after case to the Supreme Court to chip away, and then part of the political strategy was replace the members of the Supreme Court with people who had a proven track record in the courts of being hostile to abortion, so you could get a Supreme Court and finally get a case that you could do this. So the nice thing for us is that the nice thing for Illinois is that we spent lots of time, folks like Emily and the ACLU, folks in Personal PAC, Men for Choice, Planned Parenthood, you name it, taking that threat very, very seriously because we anticipated this happening and we weren't going to take chances. And it sounds really easy in theory, but as Emily said, 30 years ago, Illinois looked like Missouri. It was one of the least supportive states for reproductive rights in the entire country, and it's literally been 30 years of election after election organizing and talking to voters and making this an issue to get enough people in the state house and the state senate and in the governor's mansion to vote for those laws. And it wasn't as if once they got there, it was, they still fought us a little bit, but they came around.
Yeah, none of these has been easy, but we have, with concerted effort and the participation of many organizations over the last decade or so, really created a good framework for reproductive rights here in Illinois. So we are lucky to be where we are, given what risks are ahead of us at the national level.
Should I be the bearer of bad news?
There's bad news.
Okay.
You've introduced it already.
Yeah, all right, so we need real talk, okay? Today, if Roe v. Wade is overturned tomorrow, we're okay. But, here's the but. The Illinois Supreme Court is a 4-3 pro-choice majority today. there will literally be millions and millions and millions of dollars spent to change that in November. And there, by the way, there are 2 swing seats. There are only 2 seats at play. The rest of it, the other districts are safe Democrat and safe Republican, or whatever you want to call it. There are 2 swing seats. One is sort of crossing over in Will and DuPage County, and the other is right here in our own backyard in Lake County. If we lose, and by we I mean the pro-choice community loses both of those seats, there will be a 4-3 anti-abortion majority on the Illinois Supreme Court. The lawsuits to overturn HB 40, the RHA, and the repeal of P&A, meaning the 3 laws that Emily just listed that are protecting and guaranteeing the reproductive rights of every citizen in this state, every person in this state, those lawsuits are already written. They're sitting neatly in a desk drawer waiting for the opportunity on November 9th to be filed in court, waiting for an Illinois Supreme Court that looks a little bit more like the United States Supreme Court. And before you tell me, hey, Orrin, that can't happen, the United States Supreme Court is going to be overturning Roe v. Wade inside of the next 2 weeks. The thing that is necessary to protect the rights of people in Illinois is ensuring that that Illinois Supreme Court does not become a majority anti-abortion Supreme Court. So we are safe tomorrow, but I don't want anybody to rest comfortably for the next 6 months who cares about this issue. Because on November 9th, we could wake up with a totally different reality, and then, in that case, the fate of abortion rights in Illinois would hinge on the decision of 7 people, 4 of whom are not likely to favor abortion. That's me being the bearer of bad news.
Especially, we see the complicated play between federal law and state law, how it's all applied. We also have seen, as this conversation became even more heated in the last few months, that what happens in one state doesn't necessarily stay in that state. And there's been that effort to affect or to have citizens in one state be affected by their own state's law, regardless of where they happen to be. How is all of that coming into practice, and how is this big question mark that we're living with, how is it showing up in that conversation?
Yeah, absolutely. So just to be clear, so far, that's mostly just talk. There aren't really any states that have yet to pass a law that says if you come from Missouri into Illinois and have an abortion in Illinois, you can be punished in Missouri. But Missouri is definitely talking about doing that. This is an area where a lot remains to be seen and remains to be figured out. In the federal system that we have, there are other parts of the Constitution, there are different competing parts of the Constitution that deal with how the states interact with each other. So on the one hand, people have the right to travel from state to state. On the other hand, states have the right to have judgments issued in their courts respected by other states. And in this particular context, those things might come into tension. And these are really obscure areas of the law that no one has thought about much for 200 years, quite frankly. And they are suddenly going to become very relevant to this debate about healthcare that people can't wait to access while we wait 10 years to find out what the right to travel means, So we are definitely entering a period of a lot of uncertainty. There are good arguments that states can't do that. There are good arguments that states can't say, just because you live in Missouri, you can't go to Illinois to get an abortion. You're just foreclosed. But we don't know if those arguments are going to win the day yet. So that will be a lot, in terms of the courts and the role of the courts, that will be a big piece of the next step. And everyone has to, our abortion providers have to be thinking about that as they figure out what they're going to do. We're expecting like a multi-thousand-fold increase in the number of people who need to come to Illinois for abortion care if Roe goes away and all the states that Orrin mentioned ban the procedure. Some of those states at least will attempt to criminalize their residents from coming to Illinois, and abortion providers are going to have to figure out what their risk tolerance is and what they're willing to put on the line to provide care to these people without us having definitive answers about how those questions are going to play out.
Well, and one of the other things that is being talked about are shield laws, that a state would protect the providers in their state who are operating legally within their state according to the laws that are enacted in the state,
Right.
to shield them from prosecution if they help somebody from out of state. So it's not just the person who's seeking the abortion who needs to be protected, but it's the provider themselves. And then what happens, again, I was interested, a New York physician who was talking about if I'm providing prescriptions for Plan B to people from out of state, and I'm shielded as long as I'm in my state, but I can't then travel to these other states if I get stopped for a traffic violation, I would be, prosecuted. I could be prosecuted for treating patients legally in my state.
Yeah, and as I said, there are still things to be figured out around just how much states can shield their providers, because the other part of the Constitution I referenced says that one state has to respect the court judgments of another state. And so we're really, right now, we're all sort of in the process of figuring out what can states do to safeguard their providers while knowing that there will be some risks. And if you provide an abortion in Illinois to someone from Missouri and you get sued in Missouri, you may owe a bunch of money in Missouri, and if you ever go to Missouri, they may make you pay that bunch of money, or they may try to come to Illinois and get an Illinois court to make you pay that money, and we don't know how that's going to play out quite yet.
To your point, so far it's just talk, right? Like,
Yeah.
people are, it's going to happen. Someone's going to propose the bill. Some, enterprising anti-abortion politician in Missouri or Texas is going to try to find some way to one-up the last person who proposed a bill, and in Illinois, we're going to talk about passing laws to protect providers, and then it's going to lead to a court battle, and that's how we're all going to figure this out, unfortunately, but it's going to happen. And I think in the meantime, it's just really important to reiterate something that Emily said, which is much more practical and not about the law and not about the politics, which is tens of thousands of people are going to be coming to Illinois for abortions because they're not going to be able to get one in Missouri or Alabama or Florida potentially, or Georgia or Texas or Oklahoma. You start to go down the list. And so the practical implication just on the how does this impact the people who are impacted is it's enormous in terms of the hardship that is going to be placed onto them and their lives and their families. And folks in our state, organizations like Planned Parenthood, Chicago Abortion Fund, Midwest Access, Hope Clinic, these provider networks and these support networks are going to be incredibly stretched with incredibly meaningful and important work helping people who are in really bad situations.
And let's say we wake up tomorrow and there's a decision given by the Supreme Court that Roe v. Wade has been overturned and all the trigger laws go into effect and everything. What other constitutional protections are affected by this? What else could we see as the other fallout, the unexpected fallout, or maybe the fallout that you're preparing for, if that happens?
Yeah, I think that the anti-choice movement, up to and including Justice Alito, who wrote the draft opinion that was leaked, are trying to argue that this ends at abortion, that this is only about abortion, and that this ends with a decision about Roe v. Wade and abortion. But as I explained when we were discussing the basis for Roe v. Wade, the Constitution does not say anywhere abortion. The word abortion is not in the Constitution, and the Constitution nowhere says you have a right to have an abortion.
Pretty sure the word woman isn't in the Constitution either.
I think that unfortunately is still correct because we haven't gotten the ERA. Well, the ERA doesn't say woman, but yeah. But yes, I mean, so this was an extrapolation. This was this was a series of decisions that had come before and have come since in which the Supreme Court identified certain really important, intimate zones, things like how you bring up your child, what kind of education you give them, whether you take contraception, subsequently extended to what kind of sexual relations you have. If you have a same-sex partner, it led to the decisions for marriage equality. So there's this line of cases that have recognized this very critical zone of privacy as something that is protected by the Constitution. And Roe v. Wade is one of the foundational cases in that line. And so you can't tear out one piece and not expect the rest to then become vulnerable and fall. And so despite the protestations of people who claim this is just about abortion, their logic for why Roe v. Wade was wrongly decided, because there is no right to abortion in the Constitution, applies equally to the right to contraception and applies equally to marriage equality.
Yeah, I think that's really, really important to talk about, because the foundation of LGBTQ plus rights, constitutionally speaking, is on the basis of privacy built on the back of Roe. So if you remove Roe, then the legal architecture that's in place right now in the constitutional level to protect those rights, it's like taking a Jenga piece out and expecting the whole thing's going to stay. But here's the other piece of this. If you are opposed to the gains of the LGBTQ plus community in the country over the last 10, 20 years, and the constitutional element that those rights are built upon has now been removed, aren't you going to pursue laws designed to bring challenges to the United States Supreme Court to force the court to rule on whether or not those laws are constitutional? And then, why in the world should we trust that the current composition of the United States Supreme Court is going to somehow either ignore the precedent that it is setting by removing the privacy right that guarantees a right to abortion? Why are they going to ignore that precedent when Supreme Court justice after Supreme Court justice stands in front of the American people in their confirmation hearing and says, I respect precedent? And then if we are to believe that, what are they going to rebuild those rights on at the constitutional level, and why didn't they just do that in the first place? So it requires all of us to suspend reality and place a lot of faith in a lot of hypotheticals that, number one, the people who are opposed to the LGBTQ plus community aren't going to see this as a political opportunity, which they will, that they're not going to pass laws or try to pass laws which go at those rights, which they will, intentionally to send laws to the Supreme Court designed to get the court to rule on those, which it will. And as of today, we have no idea what this Supreme Court would do and under what precedent they would judge those specific potential cases.
This also reminds me of another thing I think we can expect to happen, which is that the leaked draft opinion and the proponents of overturning Roe are trying to present this as, we're just going to return this decision to the states. We're just going to let each state decide for itself whether abortion is available in that state and on what basis. But truly, the anti-choice movement does not want to leave this to the states. They want a nationwide ban. Ideally, they would like the Supreme Court to find that the federal Constitution has literally prohibits abortion and includes a right of the unborn. And if they can't get it done that way, then they would like to pass a law, or they would like to have an amendment to the Constitution that says, these personhood amendments is what we hear about them, that fetuses have absolutely equivalent rights to a born person. And though the potential implications of that are so broad, including things like IVF, because there are people that believe that the process of creating embryos for IVF is, then there are extra embryos that you have to destroy them, that destroys a life, and so this form of assisted reproduction would no longer be available potentially nationwide if we have a nationwide personhood law.
In some forms of contraception.
Some forms of contraception. Things like, we're seeing in states that have adopted personhood into their laws or their constitutions, custody cases over fetuses while they're in the womb, and abusive partners using a custody case over a pregnant partner as a tool. The door is open to all of those kinds of things when we give fetuses the equivalent legal status as people.
And we're coming to the last 10 minutes or so. So just a reminder, if there's any questions that you have, whether you're in person or online, feel free to type them in, write them down, and they'll make their way to our panelists here. And as you're talking about the potential things that could come to pass if Roe v. Wade is overturned, we started this conversation with Judaism believes that the health of the mother and takes priority. And so would someone be within their rights to say, my faith tradition says I have full access to abortion, and keeping me from that is an impingement on my religious freedoms?
It's a fascinating question, because this morning, a synagogue in Florida filed suit over the 15-week ban in the state of Florida, arguing that it violates their members' constitutional freedom of religion rights. So I don't know the answer to the question, but
I think it is a great question, and I think the 15-week ban is actually an interesting presentation of it, because although not exclusively, many abortions that happen later in pregnancy are for health indications. The ACLU does a lot of work in this space, because on the one hand, we believe in principles like reproductive freedom, gender equality, racial equality, LGBTQ equality, and on the other hand, we also believe in principles of religious freedom. And we have seen many instances in recent years where those things have seemed to come into conflict. And there have been many cases, including one that was at the Supreme Court last year around adoption agency in Philadelphia. Catholic Charities was denied a contract or had their contract to do adoption in Philadelphia taken away because they wouldn't agree to treat LGBTQ couples equally in the adoption process. And they challenged that all the way to the Supreme Court and won on a very narrow ruling. But these cases are really we're getting to the point where we're really sort of going to have to face directly head on if I have a right and you have a belief based on your religious beliefs, and they are coming into conflict, who will trump? Unfortunately, the realist in me thinks that they will only trump when the religious belief is the popular one or the majority one. And so, whereas I can see the anti-abortion religious belief trumping, and then the next day, the pro-abortion religious belief somehow not trumping. That's my practical view of what's likely to happen, but it's a great question.
Can I add in a somewhat fun twist to this? I don't know why I'm calling it fun, because it's not very fun, but rabbis, in case you haven't noticed, not all the Jews, in our city or country ever go to synagogue, right? Some of us are secular. Some are even atheists. And we'd probably still all say that all of us are part of the broader Jewish people. You could see another wrinkle onto this, which is that I have to prove that I actually go to synagogue and that I'm actually religiously devout in order to justify the lawsuit. And I can't just say that I'm a Jew, but I never go to synagogue, and therefore I'm not really religious, and therefore it's not my religious framework being objected to.
Right, but I don't get to determine whether you are a good observant Jew or a good observant Catholic or a good observant Lutheran or a good observant atheist. And that's, it's the basis of religious freedom, freedom of and freedom from, is that it's not being dictated by the outside. It is being represented by the individual or the community that's creating that creates the norms for that particular community. So that, yeah, I mean, within Christianity, within Judaism, within Islam, there are lots of different expressions of faith, and that's a religious community issue of how that gets dealt with and who gets canceled out of that and who gets embraced in all of that. But it is, I think, a very, very important approach to take, and to say, look, you have no right to tell me that my religious tradition is criminal, right? In that way, and there are certainly points where we come up to it. The issues of polygamy, of course, coming forward, and child brides, and you can't, tradition where you're abusing children. That's not something that we can tolerate. And so it isn't as black and white or as clear cut. It'll be very interesting to see what happens with the synagogue in Florida. But it is what I'm much more interested in is how do we think about this differently so that we, given that we are a pro-choice country, how is it that we can address what is clearly an anti-choice political and judicial system?
One option that we may have to turn to, which was how it was done before Roe, is conscientious dissent and violating the law because you believe it is immoral or unethical. And before Roe, there were many religious leaders, rabbis, pastors, who actually helped people access abortion care, counseled their constituents on how to get an abortion, if not in their state, in another state where it was more accessible, like New York. And I do think that every person we are all going to be faced with that question of, can we follow every facet of the law around abortion that may be coming, consistent with our own morals, our own ethics, our own sense of conscience, and if we can't, what are we willing to risk? That is definitely an impending decision for all of us.
Yeah, I also think, I talked about like socialization and culture earlier. I think it's really, really important that we deal directly with the myths and lies that the anti-abortion movement has perpetuated about this issue for decades. Because even people who describe themselves as pro-choice still hold on to certain stigmas and misperceptions about abortion that adversely impact the way that they make their own voting decisions and things like that. So as an example, the basic story that the average person thinks of when we start to talk about abortion is typically a young person, right? It's youth and young, reckless sexuality. That's sort of the story. Like, you should be responsible for your decisions, right? That's the way that this conversation gets framed. The reality is that the people who get abortions in this country are overwhelmingly in their late 20s. They overwhelmingly are parents, and they overwhelmingly are low income. You talked about economic health and well-being earlier. The largest plurality of reasons that people give for seeking an abortion are because they do not believe that they have the economic capacity to take care of their family, and that they would be harming themselves and their children if they had to carry an unexpected pregnancy to term. So unless we start to deal with those stories and those narratives, and I fear, unless we are explicit in talking about the harm that is coming and will come from this, we won't be able to reconstruct the political and legal framework necessary to fix the problem, because it is going to require a mass mobilization over a long period of time. But that all starts, in my opinion, with culture, which is why I always say, and I don't mean this in the way to demean the individuals who hold this view, but in the movement framework, that there's no such thing as a pro-life movement in America. It's a myth, and it's a lie, and it's propaganda. I think that at the individual level, there are people who genuinely believe, from good, decent places in their heart, that life begins at conception and all life is valuable. And I appreciate and respect that, and I don't want to demonize or dehumanize them. But the movement that is responsible politically and legally for where we are has set up straw man after straw man after straw man, lie after lie after lie, including in 2017 at the State of the Union, the President of the United States talking about after-birth abortion as if that's a thing that ever happens. And so when you allow those types of lies to sit there in the body politic, you ultimately end up creating a culture that tolerates what's happening as if it is moral, ethical, and just. And so this is going to be a cultural fight and a political fight and a legal fight. I'm very hopeful that the ACLU Harvard-educated attorneys are going to come up with the answer in shorter order than I can. But if not, I'm happy to organize for the next several decades to fix it.
As the Harvard-educated lawyer, I would say that it's going to be organizing. Honestly, the law is slow, and as we've seen, progress can be cut back, and so it is going to be about organizing and mobilizing and expressing ourselves.
And let me do a little advertising for the NCJW. National Council of Jewish Women has incredible resources.
Yeah, they've been a super important partner in Illinois on these issues.
And at the entrance, you may have seen there's some stickers and some information things and some magnets you can put on your car to hopefully promote conversation.
And for those of you who are punishing yourselves by being on Twitter, there is one of NCJW's lead rabbis, Rabbi Donya Ruttenberg, talks endlessly about this issue through a lot of the things that you touched on, and she's got some magnificent content on Twitter talking about this through a very Judaic lens, really expanding on some of the stuff that you brought up. So I would suggest following her because she's brilliant, and I learn something every time. But to your point about the organizing, job one, we're in Illinois, and we're in Lake County right now, right?
No, we're in Cook County.
We're still in Cook? But
We're
like
about a
Lake
mile
County's
away.
But we straddle both counties with
we
our
can
congregation.
do a quick, just jump 500 feet that way in Lake County. Job number one in Illinois is to protect Illinois. If you live in this state, I know everybody in this room does, if you live in Illinois, job number one is to protect Illinois. I know it's really, all of us want to get sort of gung-ho into national politics and who's the Senate candidate that I can protect and who's the swing district congressperson that I can protect. Job one in Illinois is re-elect pro-choice people. And in particular, these two Supreme Court seats, and in particular for where we are, because we're very close to Lake County. Lake County.
I live in Lake County.
All right, we're going to be talking about who you're voting for soon. We won't talk about that publicly. It'll be between you, me, and Hashem. But our job, if you care about this issue and you want to protect reproductive rights in Illinois, especially people who live around here, is Lake County. The Lake County, it's Illinois Supreme Court District 2. It is, in my opinion, the single most important race in the state of Illinois when it comes to abortion rights in 2022, which, by the way, makes it one of, if not the single most important race in America for people who care about abortion rights. Because if we lose these two seats, we no longer have a Supreme Court in Illinois that we know will protect abortion rights, which means everybody outside of Illinois, the entire South, most of the Midwest, the states all around us, every person there, we're talking tens and tens of millions of people, in addition to the, 8 million of us in the state of Illinois, are dependent on what people like us do in the next 6 months to make sure that when we wake up on November 9th, 2022, we still have a firmly and unquestionably pro-choice Illinois Supreme Court. That's job number one. Protect rights here for us and for those who need us to protect it for them. That's job one.
So we've got a task ahead of us. I want to take an opportunity to thank all of you for being here, for sharing your wisdom, for taking an hour and 10 minutes-ish out of your lives to continue this conversation. As we know that this conversation could completely change tomorrow morning or by the end of the month, and we're going to keep working and keep figuring out where we stand and how we can interact on the local and state and federal levels. So thank you, each of you, for doing that work and for bringing this conversation into this space. And I also want to take an opportunity to thank Nancy and Arnie Eisenberg and Barb and Stephen Miller for helping to organize this. This is a part of our Social Justice Committee, which is a very active committee doing programs and projects and conversations like this that are only one piece of a much larger picture. So stay tuned for what comes next. But as Rabbi Cohen was saying, we have a great relationship with National Council of Jewish Women. So there's some swag if you're here in person. Feel free to take a sticker or take a magnet, but also to keep looking at all those posts and articles and all the wisdom that comes our way to continue to think about what does this mean for us as people, what does this mean for us as a Jewish organization, and what does this mean for us as a state and a country. We'll see what happens. Thank you so much. Have a lovely rest of your evening, and
Stay
we'll
hydrated.
see you soon. Stay hydrated, absolutely. We have more questions than we have time for, so if you want to stay here until midnight, we'll see what we can do, but otherwise, I believe...
I mean, I'm happy to stick around for a few minutes if anyone has a question.
And you've got some emails available too, right?
I don't want to disappoint Lee.
So there are continuing opportunities for the conversation. We would not stop this talk here now, but maybe in different formats. Thank you and good night.